welcome everybody to our webinar on state laws, legislation, and research addressing the age of juvenile court jurisdiction. Again, my name is Rich Williams. I'm a policy specialist here in our criminal justice program at NCSL. And we're bringing you this webinar through our partnership with the Tao Foundation of New Canaan, Connecticut. So I just wanted to take a moment and thank them for their support that enables us to bring you resources like this webinar. So thank you, and with that, we will begin. So first, here's just a quick look at our speakers today, and we've had some changes, so I just want to give you a heads up on those. First, you're going to hear a little bit from myself, and then after that, I'm grateful to say that we're going to have a good lineup, starting with Stephanie Coleman, who worked on raise the age issues in Illinois, and specifically authored the Illinois Juvenile Justice Commission's report back in 2013 that was really informative for their legislative efforts that later passed in 2014. She'll be followed by Brandy Bynum, who's worked a lot on juvenile justice raise the age issues in North Carolina, and she's stepping in for Representative Marilyn Avila, who unfortunately today had to go into a session on redistricting issues. And then after she speaks, she'll be followed by Representative Ron Hicks of Missouri, who has a current pending bill on this and closely related issues in his state. So I also wanted to just say thank you all for being here and participating on the webinar. So to start off on this slide, this is the issue that we're talking about. This is the upper age of juvenile court jurisdiction across all 50 states. And since it's the focus of the webinar, I figure it should probably be defined. And so the upper age juvenile court jurisdiction is the age at which, if crimes that were otherwise committed by adults but are committed by people of a younger age, they're prosecuted in juvenile court. And so you can see here 41 states have set the upper age juvenile court jurisdiction at 17, again meaning that 18-year-olds and up are automatically prosecuted in adult court. The 7 in dark blue set it at 16, and 2 in New York and North Carolina set the upper age of juvenile court jurisdiction at 15. And just as a quick side note, I did want to say that that's not the only way. That's not an automatic thing that kids either end up in adult or juvenile court. There's also other mechanisms in place. So I just wanted to mention those quickly. Those are automatic transfers. So for some certain violent crimes like murder, youth at younger age can be sent directly to adult court. And then there's also other mechanisms that can either put a kid in adult court or in juvenile court, and that's prosecutorial and judicial discretion, which basically sound pretty close to what they are. And that's where basically prosecutors and judges have the discretion as to whether or not to bring charges or to have a case heard in adult or juvenile court. I'm not going to address those issues here, but if you'd like more information on those, please feel free to email me and I'll send you more information about that after the webinar. So back to the issue at hand. Here's a look at recent state actions that have occurred over the last couple of years on the age of juvenile court jurisdiction. And the trend has been to raise the age up to 17. We've had 4 states since 2009, starting with Connecticut. Much of those efforts have been fueled by, and the underpinning aspect of it, for a lot of juvenile justice reform nationally, has been an evolving understanding of youth brain development science. And this has touched on not only the age of juvenile court jurisdiction, but it's also affected areas like life without parole and the way that juvenile sex offenders are addressed as well. And so the basic principle of that is that brain science is showing that you don't reach full mental maturity until the age of 25. And so you can see the way that that's been written into Supreme Court jurisprudence like Miller v. Alabama, where they talk about how youth should be considered as a factor in a juvenile's actions because of the impulsivity that's attached to not fully mature brains, and that their actions may be more related to their youth rather than an inherent criminal nature. And so another thing I want to point out is in the media library that's attached to this, the downloadable presentation will have links out to a bunch of different slides. And so the first place where, like on this slide, if you download it, it would have been linked out and by where it says, it talks about Connecticut. in the NCSL Juvenile Justice Policy Roundtable. That's an event that we held earlier this year, and you can find a presentation there by Dr. Jennifer Woolard, and she goes much more in depth and has a much better understanding than I do of the actual brain science that goes into those efforts. And so I've also put a bunch of other information up here, and most of these things are linked out to in the downloadable presentation too. The reason it's not linked to here is because we found out that when you click on it here, it takes you out of the webinar, which seemed counterproductive. So on here, Connecticut being the state that, of the recent states that have raised the age of juvenile court jurisdiction, did it the longest time ago, and they probably have the best data after to show what the impact of it was. And that presentation is by Mike Lawler, their Undersecretary of the Criminal Justice Policy and Planning Division. And if you click on that in the downloaded slides, you'll be able to see sort of their most up-to-date information on what the effect of raising the age has been in Connecticut. And then similarly, Massachusetts, they have some information available in that report on sort of what they've seen since they've raised their age of juvenile court jurisdiction. And then Stephanie in a bit will talk more about Illinois' efforts. And New Hampshire is just talked about how they're going to start collecting data and information in the report link there, and they're calling in some experts from Massachusetts to help them look at that. But so that's just been the legislative trend the last few years, is raising the age of juvenile court jurisdiction, and it's mostly been driven by the considerations for mental maturity. The counter to that is concerns over what the cost and caseload of transferring those cases from adult to juvenile court would be, and also what the outcomes on public safety would be. And so far from the research, as I mentioned before, in the Connecticut report and other places, the research on that seems relatively positive. But Stephanie will be able to tell you more about that in a little bit. Okay, so moving on, I wanted to go over some of what's happening this year in terms of pending legislation. Of the states that have a lower set age of juvenile court jurisdiction, there are 4 that I was able to find pending legislation for, and that's South Carolina, Missouri, Wisconsin, and Michigan. You'll hear more about Missouri in a little bit from Representative Hicks, who's sponsoring a bill there to raise the age of juvenile court jurisdiction. Michigan, just earlier this week, they had a bill that got to the floor of it now has a hearing on the floor of the House, and that's sort of a bigger bill package. And again, in the downloadable links, you'll be able to click out and you can go directly to the bills currently being considered in each of these states. And I believe in Wisconsin, their legislation has moved and is now in their, I believe, Judiciary Committee, but I know that it's definitely got to committee. And then at this time, I'd like to extend, and we're grateful to have on the phone J.J. Gentry, who is a staff attorney for the South Carolina Judiciary Committee, and their bill has just recently moved into subcommittee, and he's going to give us a brief little update on what the action has been like in South Carolina and some of the issues that have come up there. So, J.J.?
Hey, let me check to make, you can hear me now, right? Correct?
Yep.
Okay. Thank you for having me. I'm a staff attorney for the Senate Judiciary Committee. I handle all the criminal law for South Carolina, including the juvenile law. And we have a few bills going on right now. The main bill that I'm working with is S-916. It's a bill that was introduced primarily by Senator Malloy, but has been joined by Senator Fair and Matthews. The reason I mention that is I think it's a key component to these bills. Senator Malloy is actually a Democrat, even though we are a Republican-dominated state. He's also a minority, yet he has been recognized by the rest of the legislature as being a sentencing reform type expert, really across the country. And so he gets a lot of attention from our other senators as to different type of movements that are going on within sentencing for juveniles and adults. The other sponsor of the bill is Senator Fair. He is a very conservative Republican, and he holds the purse strings here in the Senate for any of the bills that go through and how they're going to spend on those bills. He also happens to be the chair of the Corrections and Penology. I mention that just to say that you've got two different extremes who are sponsoring the bill together. And this bill, in the simplest terms, basically raises the age from 16 to 17. So we would go from being one of these blue dark blue states to one of the teal blue states, I guess you'd call it. And it does other things with transfer of jurisdiction, but since we're not talking about that, I won't bring that up. There is a companion bill in the House. That bill is H 4730, actually. It was just recently introduced. And again, that bill has been introduced and co-sponsored by both a minority Democrat and a Republican who is on the Ways and Means Committee controlling the purse strings. It's interesting to note that that representative as well is a former law enforcement officer. So you've got two bills that are companion bills in the House and Senate that do the same thing, and that is to raise the age from 16 to 17. We have a third bill, which is H 4547, and that bill actually was introduced in the House side by two representatives that would raise the age to 21. They received a presentation that showed that actually childhood and juvenile ages might need to be considered beyond 18 and all the way to 21. So whereas a lot of the states are doing things to raise it up to where it's 17, they're looking at raising adulthood to 21, so it would be 20 and under. I do not sincerely think that that bill is going to get a whole lot of traction. I believe the most important bills are going to be S 916 and 4730, because I think the feeling is moving towards the 17, not all the way up to 20. I would mention, just kind of in conclusion on this, that the bill S 916 is very timely right now because it's coming up this coming Wednesday, the 24th in the morning. We will be having our first subcommittee meeting on Raise the Age, and I do anticipate the bill to come out of subcommittee and go to full committee. It may not come out as drafted, but I do think it'll come out where it will be proposed by the subcommittee to go from age 16 up to 17, and then I do believe there's some movement to keep the bill going. Our only restraint in South Carolina would be our session ends the first week in June, so we've only got a few more months to get it passed. If it doesn't pass, it has to start over next year. So I think there's going to be a concerted effort over the next few months to get it passed. But Rich, that's about all I've got as an update for now. I'll have plenty more after next week.
That's perfect. Thank you. Thank you so much for being willing to share that with everybody. I appreciate it. And so just before I move on from pending legislation, so as I mentioned, there's these bills going on in a few other states, but there's also been activity in a few of the other states that don't have current pending bills, and you'll hear more about that from Brandy Bynum in a minute. And then also just I'll make some notes as to some of the other actions that have been going on here on the next slide. And again, these reports are able to be linked out to on the downloadable slide. So if you click on the pictures, it'll go directly to the full reports. The New York one's not really so new at this point. It was released last year in January 2015. That was created by Governor Cuomo's executive order that brought together a bunch of experts and officials from around the state to come up with a plan for a couple of things in juvenile justice, including a plan for raising the age of juvenile court jurisdiction. It informed legislation that was developed last year but didn't ultimately pass, and there have been a few subsequent executive orders issued that have had some impact on the juvenile populations there, but as it stands, there isn't currently any legislative action in that area. And then also, I wanted to mention Louisiana. This report actually just came out the 1st of February, and similarly talks about a lot of the different, again, both of these reports recommend raising the age of juvenile court jurisdiction and sort of, for their individual states, point out like what the financial and public safety outcomes and mechanisms would be for that. And so while Louisiana doesn't have a bill introduced, this, based on the resolution last year, this report was created sort of to inform efforts in their state going forward to address some of the age of juvenile court jurisdiction issues that they are dealing with. And then the last thing I want to mention before I turn the floor over, made bigger news back in December, but in Connecticut, and as I mentioned, they had raised their age back in 2009, sort of a graduated phased way. They've started talking about the possibility, or the Governor Danelle Moy started talking about the possibility of raising the age to 20, given some of the brain development considerations that I was talking about. And again, in the downloadable portion, this picture would link out to a conversation he had at the Harvard Kennedy School, talking for about an hour on his perspective on it. And I don't think it didn't sound like he was necessarily pushing an initiative, but just sort of starting the conversation about how they think about juvenile age and criminal culpability and what that should mean for their system as a whole. It was an interesting talk. If you have a chance, I definitely recommend listening to that. And so that does it for my portion. Now I'd like to turn the floor over to Brandy Bynum from North Carolina, and she's worked on their efforts over the last couple of years on age juvenile court jurisdiction legislation closely with Representative Avila, as who I mentioned, is working on, they got pulled into emergency session today, work on redistricting issues. But I'm excited to hear what Brandy had to say. So Brandy, the floor is yours.
Thanks so much, Rich, and hello, everyone. Again, my name is Brandy Bynum. I was previously to my new role a policy director at a statewide advocacy organization, so have a long-standing history in the Raising the Juvenile Age campaign in North Carolina. As you all probably know, raising the age has been, or juvenile court jurisdiction has been an issue in North Carolina since the day that it became, or the year it became law, which was back in 1919. So we're talking almost 100 years that this law has been on the books in North Carolina. And I've worked on the issue or legislation since about 2006, so that was the first year that the first Raise the Age bill in the last 10 years was actually introduced in the North Carolina General Assembly. So there have been several sort of iterations of the legislation over time, and I'll get to, I think, the more recent, more present right now. But there have also been several studies of the Raising the Age issue in North Carolina as well. So 2007 was the first kind of statewide study that was done by our very own North Carolina Policy and Advisory Commission, who actually recommended that North Carolina raise the juvenile age. Then again in 2008, our very own Governor's Crime Commission also commissioned a study, and again the same recommendation is for North Carolina to raise the age. You'll see a theme as I keep going. In 2009, a bill was actually introduced, which included both felonies and misdemeanors, and that bill unfortunately did not move. There was also a companion bill in both the House and the Senate, but unfortunately that bill did not move. However, what did happen is that legislators did put into the budget that year funding to allow for an additional, more comprehensive study of the juvenile court jurisdiction age in North Carolina, which included a sort of mini cost-benefit analysis. And so from 2009 to 2011, another commission, a statewide commission, was established called the Youth Accountability Planning Task Force. And for 18 months, that task force convened, including working very closely with the Vera Institute for Justice to develop and commission a very thorough, actually, cost-benefit analysis around the issue. And so recommendations from that task force were also put forward towards the state and to our General Assembly that, again, recommended raising the juvenile age from 16 to 18, this time including low-level felonies and all misdemeanors. So, again, a bill was introduced in 2012 that pretty much mirrored the recommendations of that Youth Accountability Planning Task Force. That bill did move within the House of Representatives through several judiciary committees, but unfortunately did not make it to the floor of the House. Now, I do have good news. In 2014, with Representative Avila's stellar leadership, we were able to pass House Bill 725 through the House of Representatives. And as you can see, there's obviously great news there because that had not been done in the years prior to that introduction of the bill. And that bill passed with significant bipartisan support from a vote of 77 to 39, which obviously showed that there was, one, a lot of education and headway that was made on both sides of the aisle. But again, both sides of the aisle agreed this was something that North Carolina needed to make happen in the very near future. Unfortunately, in that same year, once we were able to get the bill through the House, the bill was actually stalled in the North Carolina Senate. And so had to start over again in 2015, where Representative Avila so bravely introduced yet another piece of legislation, House Bill 399, again, which was for misdemeanors only at that point. So the previous bill in 2014 and the following bill in 2015 was only to raise the age from 16 to 18 for misdemeanors. The other components of the legislation included developing a statewide kind of monitoring committee. So North Carolina wanted to be very thoughtful about once the legislation is passed, how we're going to make sure that we kind of work out the kinks, so to speak, as we move along. And I think one thing to note is that we have had advocates and officials from both Connecticut and Illinois that have come to North Carolina several times. We wanted to make sure that we get it right in North Carolina, and so working very closely with states who have done this already to learn from their successes but also from their challenges, so that we have more of a seamless process in moving forward with our legislation. So establishing a monitoring committee was also in the legislation, as well as establishing a civil citation process or program that would initially be piloted in a couple of key jurisdictions across the state, both a very thoughtful mix between urban and rural, as a way to address the concerns of law enforcement as it relates to the time that it takes to manage or handle a juvenile versus an adult. And so the civil citation program or process was an idea or proposal that would allow law enforcement to expend more of their time with the more serious offenders, recognizing this bill, again, was only misdemeanors. So they would issue a citation at their own discretion. The other thing was the last two versions of the bill, House Bill 725 and 399, is that North Carolina, again, wanted to be very thoughtful about, how we allow this implementation to happen. And so there'd be a 4-year phase-in before the first cohort of 16-year-olds would be moved into the juvenile system. And then the following year, the next cohort of 17-year-olds would be moved into the system. And so that's bringing us up sort of to 2015 and what happened with that legislation. So a bill was introduced, actually, but it was never brought up in the House or a Senate committee. There's a lot happening within the North Carolina General Assembly in 2015. And I think we just got really, really busy, and that bill obviously never came up for a committee discussion, nonetheless a vote. And so what did happen in 2015, nonetheless, was building and expanding both the internal and external leadership and support for the legislation or for the issue. 3 major things have happened since then, which have been, there have been 2 task forces that were established, not solely focused on the juvenile court jurisdiction age, but issues relevant and related to the age of juvenile court jurisdiction. So our governor established a mental health task force, and they recently, as of 2 weeks ago, put forth a recommendation that North Carolina should raise the age of juvenile court jurisdiction from 16 to 18. So that's obviously coming at the issue from a very related but a very different angle from the mental health perspective, which is a great thing, and moving forward and building additional momentum for the issue. In addition, our state Chief Justice also established a commission on the administration of law and justice within the last year. And most recently, that commission has also had a very thoughtful and concerted and comprehensive conversation about the age of juvenile court jurisdiction and how North Carolina remains one of 2 states. So that commission has not established their final recommendations. However, I feel very confidently that raising the age will make it sort of on their list of final recommendations. At the same time, our commissioner of the Division of Adult Corrections and Juvenile Justice has also been very vocally and visibly supportive of raising the age of juvenile court jurisdiction. So much so that he has pretty much told the legislature that he can be sure that there is a way to integrate 16 and 17-year-olds in the current juvenile justice system without a significant or insurmountable and additional resources. So I'm looking forward to working with them very closely and seeing what 2017 holds. As you guys may or may not know, 2016 is a short session for North Carolina, so they would go into session probably mid-April and potentially be done June, July, depending on kind of what's on the agenda. And so because the last bill, House Bill 399 in 2015, did not make it through a legislative or judiciary committee, the bill is not viable for the short session, which means that we will, in essence, have to start over in 2017 with a new version of the bill. I think, in addition, since that time, some more promising things that have happened are the potential to include low-level felonies in the 2017 version of the bill. I'm not Representative Alba, so I'm not speaking for her, but have had conversation with her where that is a potential. There's also a potential to bring on additional support from those who may have been seen in opposition in previous years. So with that, we're looking very much in favor to that, while at the same time being able to allocate additional funds, the General Assembly, not Brandy, allocate additional funds to the juvenile justice system on the prevention and community-based services side of the system, which we know majority of these kids would end up, and less on the costlier side of the system, which is housing them in facilities. And so we're looking forward to some potential support through the General Assembly as it relates to more prevention and diversion dollars to ensure these kids end up in the part of the system that best meets their needs.
Well, thank you, Brandy, for that update on North Carolina. I really appreciate it. And then at this time, I'd like to turn the floor over to Stephanie Coleman, who is the Policy Director at the Children and Family Justice Center at Northwestern's Pritzker School of Law. And she worked on Illinois' Raise the Age, or Illinois Juvenile Justice Commission's report related to Raise the Age back in 2013 and 2014. So Stephanie, the floor is yours.
All right. Well, good morning, everybody, or afternoon, depending on where you're sitting. And hello to Brandy. Nice to hear your voice again.
Hi, Stephanie.
Hi. So we at Children and Family Justice Center help to provide some of the research support to the Juvenile Justice Commission in fulfilling, as every state advisory group is to advise the governor and legislature on good policy. When this discussion of raising the age had been percolating around for several years, it was eventually decided that the way through that we would have is doing it in stages. So something a little bit similar to how Brandy had discussed, and I'll talk a little bit about the successes and difficulties of the way that we chose to move forward. So first of all, I want to let you know about sort of our interim report, which was published as a reflection back on how the raising the age went for misdemeanors and making recommendation on how to raise the age for felonies. Some things that the Commission was concerned about and wanted research available for the report, and what the impacts of each of the stages of raising the age are, and sort of where we're at today. I don't need to go through the detailed history, but I think one thing that, we had started with a fully raising the age bill, and there was a sort of Springfield compromise that happened that resulted in raising it just for the misdemeanors and adding a study component. That study was later given to the Juvenile Justice Commission to complete, and I think the thing that's important to point out is that the Commission was tasked with studying the impact of what had already occurred and also making specific recommendations for how to move forward with the second half. And I think you can tell by the language of the statute of the charge that what was expected to occur, propose a funding structure to accommodate the expansion, was not in the end what was required in order to pass the second phase of the reform. So the Commission report involved research into the status of the law in Illinois and around the country, best practices, youth development, a lot of data requests, and a fairly significant portion of the time was spent on practitioner interviews, asking people around the state from all points in the spectrum, from law enforcement all the way through to our state incarceration, how their experience with raising the age had been going. The first question the Commission wanted to address is why we need to have such a bright line rule anyway. This was a specific concern because we'd done it in stages, and so there was this sort of limbo for 17-year-olds where sometimes if they were misdemeanors they were youth and sometimes they were adults. And the Commission sort of, on discussing it, and especially with the information that had come out from the stakeholders, it was very clear that there were some specific reasons that having a bright line categorical age of jurisdiction rule was really important to practitioners. That there were ways in which when youth who are misbehaving and encountering law enforcement, that's not their best moment, and there's a lot of discretion that comes in at that point that really was creating some skewed results. Some youth were being treated as adults, some as juveniles, and in some cases, a youth's ability could be held against them and they could be perceived as more adult-like and therefore suitable for the adult system. And similarly, their inability was also seen as an aggravating factor by some, which is that, well, if you're doing this sort of an action at this age, then you must therefore be on a longer-term criminal trajectory. So there were some sort of disparate results that we were seeing from the compromise that was in place at the time. On a review of where the status of the law is in Illinois, some of these are federal laws that will be familiar to most of you, but you can see that on balance, the age of 18 really is used as the cutoff age of majority for most other purposes. Our parental tort liability actually extends through to include 18-year-olds. Their parents can be sued for 18-year-old misbehavior, but in most other respects, the weight of obligations that are placed on youth occur at 18, and so there are only some sort of minor, or relatively minor decisions like truancy and rated R films that are attaching at the 17th birthday. For most respects, we don't treat 17-year-olds as adults. And in fact, there has been some discussion of raising the age for truancy in Illinois since then. The Commission was also interested in the Supreme Court decisions and what they're saying, and in terms of deciding which offenses really should originate in juvenile court, whether they were later transferred or not. I think the considerations that the crime specificness is really not a consideration in dealing with whether an individual youth is presumed to be a juvenile or an adult. That they're, it's not the level of misbehavior that's occurring at that time that drives whether youth are youth. And so there are a lot of other considerations that need to be taken into account, which our juvenile system accounts for and our adult system not as much. Obviously, the juvenile system has a lot more protections than the adult side, and while I think a lot of these were of interest to the Commission to really find out how the adult system was different than the juvenile system and what that meant in practice, I think the most salient ones to the commissioners were the fact that there is youth expertise and service available in juvenile court that simply doesn't exist in even the most beneficent adult judges who are used to dealing with younger offenders. The services still are not there, and the parental obligations and notification practices are not there. And of course, the most damaging thing to a young person's ability to move past their behavior, which is the permanent felony conviction, exists on the adult side and is not an obstacle on the juvenile side. The best practices review really was assisted a lot by the CDC report. Obviously, public safety is the charge of the Commission and a key concern of the Commission. And the sort of CDC's full review of studies that have been done over time with thousands of matched pairs, as they call them, of youth, who are identical in background and in resources and every ability to match geography and everything else, one of which went through the adult system, one of which went through the juvenile system, and consistently seeing that outcomes and safety were better through the juvenile system, that they were 34% more likely to be rearrested if they had been treated as adults. And obviously, other types of safety risks are of great concern, such as the likelihood of committing suicide or attempting it. Obviously, younger people held in the adult system are frequently held in isolation, and that only exacerbates any mental illnesses that they may have already been dealing with prior to arrest. And so when it comes to whether we're reducing or increasing our violence is a particular concern. In Illinois, I'm sure it is in all of your states as well. Whether our legal approach was supporting violence reduction or not was clear that it certainly was not at that point. We also were concerned, and I think this was really a large portion, along with the safety concerns, of derailing the first attempt to raise the age in Illinois. Were great concerns about the system effect that it would have. North Carolina had previously had Vera Institute of Justice do a cost-benefit analysis, as Brandy mentioned before. We felt, upon looking at the CDC recommendations, that maybe their cost-benefit analysis was a little bit conservative. It used a 0 to 10% recidivism reduction among kids going through a juvenile as opposed to adult, whereas the CDC research said that it would be somewhere potentially between 30 and 40%. So we reworked those numbers, and also were looking at ways that youth actually paid into the system by virtue of not having an adult felony conviction and growing up and having the ability to attain more meaningful employment. The difference in the taxes that they would pay over their lifetime was, I think, a significant financial concern, and also support for the changes. There was, and we'll talk about what happened with our caseloads, there was a understanding before the age was raised for misdemeanors that we could expect our system and therefore our system costs to increase by about 35% by adding 17-year-olds. That certainly didn't come to pass, and we'll talk about what did in just a minute. Obviously, the brain development research, with which you all are familiar, was a key concern for the Commission, but I wanted to make sure that we included it in the slides here so that you could remind yourselves of the point at which youth quickly age out of this violent or nonviolent behavior. I'm going to turn on my cursor really quickly because I'm going to have a lot of charts coming up. And I just want to point out for all of you, these are the youth right here that are very soon going to stop committing even nonviolent crimes, and certainly violent crimes also begin to drop quite quickly. And so they are tagged for the rest of their lives with this felony conviction. That was a key concern for the Commission. We got some research. Many of you may be familiar with Ed Mulvey's Pathways to Desistance project, where he tracks over time the outcomes of serious youth offenders. This was important to us because it's youth with weapons offenses, sex offenses, serious crimes, and felonies. Obviously, we had already raised the age for misdemeanors, and as you'll soon see, there was very little system impact. But there was a concern that perhaps the older offenders, 17-year-olds at the felony level, were somehow instrumentally different than 16-year-olds, 14-year-olds, the other sorts of kids that were coming through juvenile court routinely that the system was equipped to deal with. And Mulvey's research really showed that these bottom three categories are the categories of youth. He told me the low stable, this is like a ordinance violation type category. This is like a misdemeanor category, and then these are people who aren't reoffending at all. So, we're at almost 80% of the youth who have very serious violations at 14 through 17, you see the outcomes are pretty similar, are not going to go on to have a serious criminal incident. And so obviously the 20% we need to be doing something with. As the question is, what keeps them and the rest of us the safest? It isn't always the adult system, but certainly for the rest of these youth, there is no public safety benefit at all for putting them through an adult system. So the system impact, and you'll see these slides are a little bit dated, both because of our data lag at the time of our report, and also the report was about a couple years ago, but this is what happened once we added our misdemeanors. Obviously, there was no crime spike, and this is not a youth-specific crime graph, but what I want to point out is that the thing that was projected to happen possibly as an unintended consequence of doing this in two phases was that in those instances where law enforcement would have discretion of going through the easier, faster adult procedures, as they put it, or the complicated, more onerous juvenile protections might just lead law enforcement to start arresting and charging youth as adults. And what you'll see through this bottom blue line with our felony arrests is that there wasn't a sudden surge of law enforcement arresting at the felony level where previously they had not. Now, this is just for 17-year-olds, and you'll see this drop off. This is because once you're on the juvenile side, many misdemeanors arrests are not reported to the state data repository. Those are optional reporting for misdemeanors on the juvenile side. The size of the arrests that we expected to have to accommodate was 18,000 misdemeanor arrests of 17-year-olds statewide, 2009 being the last number that was fully available for us. And then you'll see that there are some concerns. I mean, there's this gray area that was a lot of discussion during the interview component of when is something a misdemeanor, when is it a felony, and whether this gray line, exactly how that would play out in practice. And then, of course, like Rich mentioned earlier, our transfer laws at that point we left completely alone. The ability to transfer youth remained unchanged. So there was expected to be about 4,000 felony arrests that we would have to begin accommodating in when the second phase of raise the age happened. As you can see, and this is why it was really important to the success of Raise the Age in Illinois, that it occurred during the shrinking of the system overall. It's not that raising the age necessarily instantly caused any crime decrease, but that, as you can see, this was happening prior, and that trend continued, and therefore adding these 17-year-olds really resulted in a system that was about the same size as it had been prior to raising the age, right? So it was almost like, rather than creating a new scenario where we had to accommodate new kids to the system, we were merely setting back the clock 3 years. Because crime had been declining, we were at 2008 levels perhaps in 2011, rather than having some surge or increase, the threats that the system would be crashed that people had been initially so concerned about. Our juvenile petitions actually went up a bit. You can see that that's mostly because of some activity in Cook County. It's possible that that is a regional choice and not necessarily a crime pattern, as the rest were decreasing. But overall, the statewide juvenile petitions before and after remained pretty steady. The court caseloads remained steady. And as you all know, juvenile court really is a small piece of the work of the entire court system. And so, the idea was that if there were additional resources that the court was needed, there is a whole host of court services that might be able to be reallocated in order to handle the 17-year-old felons. But in the end, that wasn't required. Our probation caseloads prior to and after raising the age for misdemeanors did not increase at all. And I think that's really interesting for us because that's where we expected most of the misdemeanors to go to. You'll see in a minute that our detention and our state incarceration didn't increase. For misdemeanors, that's not surprising. But in our probation caseloads and our court caseloads, there really was no change, exactly because of what I said before. Crime was on the decline, and so when we added 17-year-olds, there wasn't a sudden surge. Our juvenile detention centers, there had been discussion of the fact that raising the age would probably result in us having to build a new detention center. As you can see, however, we were already under capacity, and that capacity had increased prior to raising the age. It continued to increase after raising the age for misdemeanors. And of concern to our commission, of course, everything is very regional, particularly with detention. That capacity was stretched throughout the state. It wasn't just located in one pocket. The population in our state facilities also continued to decline pretty dramatically, and Illinois is not necessarily unique in this respect with what we were doing in the mid-2000s to what we were doing in the mid-teens. But, it's important, I think, to think about loss of history and loss of people who are familiar with dealing with juveniles. As the system is shrinking, it seems like a good time to make sure that the system contains everyone in it that it ought to. It's once you've lost juvenile judges or you've lost juvenile facilities, those are maybe important consequences of a system that's shrinking to match crime going down. But the point is that it's a good time to make sure that you're adding the full caseload that you need to be incorporating for best practice reasons in the juvenile courts before those people are gone, because then trying to rehire in order to ramp up to capacity, I think, would have been operationally a lot more difficult. And so the result of our misdemeanor experiment was that obviously the 35% increase did not occur. to be fair, that 35% increase did include having gone with the felons. That was the projection. In fact, we were down in almost every single category following raise to age, and I can answer questions about why that might be later. I want to make sure that we get quickly through the rest of the presentations and speakers here. But I want to point out, too, that it was true while we had our split that there was a very severe racial disproportionality between our 17-year-olds who we were putting in our adult system and the 17-year-olds that we were putting in our juvenile system. You know, this is the percentage of African American youth around the state, and this is those in detention on juvenile charges. This is the adults. So we expected that raising the age for everyone would help to reduce maybe some of the disproportionality we saw. I'm going to quickly go through the fact that we had these interviews, as I mentioned. We found very interesting concerns about wanting a brightline rule. Those who had previously said that they were against raising the age, which there was a lot of concern from a lot of system actors about capacity and about best practices. By the time that we had succeeded with rolling out raise the age misdemeanor, had said that this is the question of whether to continue raising the age for felonies. And as you can see, all the practitioners that we interviewed ended up overwhelmingly favoring raising the age for the felony use. And so the commission concluded that adding all of the misdemeanor arrests didn't crash the system. There was no detrimental effect to public safety, and recommended then that raising age for the felony use would be consistent with the information that we'd found so far. It wasn't going to overwhelm the system. There might be some costs attached to it, but that those would be matched or by benefits and also by best practices and safety. So they recommended going ahead with the felony. We released a report, and we raised the age for felonies effective the beginning of 2014, as Rich said before. There isn't current data quite available yet on 2015 for the juvenile detention centers. As you can see, adding the felony use did result in an uptick. Again, this is still well below where we were at before we raised the age. So while there has been some impact on our detention centers, we're not at 2009-10 levels even yet. And you can see that the age has shifted toward a little bit older population in the detention centers, but it's not youth that we've never seen before. That was a practitioner concern prior to raising the age, that there would be these older youth and we wouldn't know how to handle them. You know, this is just a slight shifting in who we have at the detention centers, but it's not dramatically different. We did notice that the youth that were in the detention centers, many of them were automatic transfers, so they were in detention centers for very long periods of time awaiting adult charges, and in fact, this last year we went forward with automatic transfer reform as a separate later bill that we think will have a population reduction effect on the detention centers. This is not due to raise the age, and we can't claim any raise the age success, but I think it's really important to show how raising the age in the context of other very important reforms can result in a net smaller system. There were parole reforms, there were other now misdemeanants and status offenders can no longer go to our state facilities, and as a consequence, as of just a few days ago when we announced a facility closure, there were only 438 youth in our state system. So as far as the supplemental recommendations from the Commission, and I'll end here, in addition to the felony youth being included, the further recommendations are being considered. I believe there will be a bill on several of these ideas this year, in addition to the third prong here, which was passed last year. I'll end there.
Oh, thank you, Stephanie, for that great information. And before we get to our final speaker, I just want to say again, if you have any questions, we'll have a sort of abbreviated Q&A. You can put them down in the chat box in the lower left-hand corner. And with that, I'd like to introduce our final speaker, and thank you, Representative Ron Hicks of Missouri, who's working on these issues in his state this year. Representative Hicks, the floor is yours.
Hello, everybody. Thank you for your time today. Actually, like some of the information that we heard today, it's going to help a little bit with what I'm dealing with here. I had House Bill 1812, which this bill refines the term child to include any person under 18 years of age and redefines the term adult to mean any person 18 years of age or older. The bill will repeal the definition of status offense. It's very similar to the bill that I held last year in 2015, which was House Bill 300. I'm just now starting to get some good traction on this bill, of course, because I had to, of course, file a couple of bills that no one wanted to see or hear, which gave me the opportunity to bargain with this bill to say I'll drop those if we can move this. And lo and behold, a week later, it was referred to committee, so I'm just now waiting on the date for the committee hearing, and I'll move forward from there. This was something that I started up actually 3 years ago. My first year in office, I started looking into this. For one reason, I actually did not realize that the age was 17 in the state of Missouri, and I found that very odd. I grew up in a state of, it was 18. 18 seems to be everything as far as being able to sign documents or be able to buy a car or a home or bank accounts, things like that. So it was just odd to me. And then that at the end of that year, a lady came into my office and she was pleading with me to help her because her son had been ditching school. And this lady explained her life story to me, which, I understood what she meant. I kind of lived it myself. And she had talked about how she grew up in poverty and, divorced parents, a broken home, just, didn't know where they were going in life. And she wanted to break that cycle in her child's life. And so she was trying to pay attention to his schoolwork. And she called the school, and they would not release any information to her on this child. She couldn't figure out why, and it was because he was 17 years old, and he's now considered adult in our state. She found that very odd. Come to find out, the young man had actually been skipping school, and they never told her about it because they don't have to call her anymore. He's 17 years of age. And I know this is a kind of refined situation, but even if it's happening once, twice, or 3 times, I can see the concern there, especially when she's trying to better her family name for the future, and that means a lot to me. I'm doing the same thing with my family. And so that's one of the reasons I wanted to file a bill as such. And it's gotten a little bit of opposition here and there, but most people that I talked to still didn't realize that it was 17 as well, so at least I wasn't alone on that. And some of the representatives have reached out on both sides of the aisle to let me know if they'll support this bill. They'd like to see it. They're starting to get a few letters on it and stuff like that, which is good as well. I just can't understand how a parent is responsible for a child at 17 when they're considered an adult. When they turn 18, the parent is no longer responsible in our state. But right now at 17, they can go off on their own, do whatever they want, and the parent can't stop them. But yet if something happens to said child out in the streets, the parents are held liable in our state. And that's another thing that concerns me. We have to be transparent on what we're doing. We also have had a tremendous drop in our youth being incarcerated and getting into trouble, and all youth being youth, and that's just it. They're youth. They're 17 years of age, but in our state, they're not. They're considered adults. So when they're being arrested, that is the definition of the offense. You're 17 years of age, but in the state of Missouri, we recognize that as an adult offense. Their fines are higher. Their jail times are higher. The penalties, of course, for everything are going to be elevated compared to if you were a juvenile or you're an adult. Which in return, we also have less getting in trouble at the age of 17, which also means we have less getting in trouble at the younger age, because as we know, most of this time it's a trend and you take it with you throughout the years of your life. But with it also, the trend starting with the younger kids too, the crime falling and less of them being in trouble, our juvenile system, our facilities actually have room to be able to hold more children. So another reason to repeal this back to the age 18 instead of 17, because our juvenile justice system can handle 17-year-olds, which would also in return free up jail space for more serious offenders of the adult age. I don't really have too much more. As the bill moves on, I will come up with more on it. I just wanted to give my views and points. Of course, there's lots of studies going around, and then today I heard a lot of things because one was brought up of the court systems about our judges and our juvenile justice systems disappearing or being sold off because they're not being used, and she's right. It would be a much greater cost to our state if we closed down places and got rid of judges. It would be a much greater cost to our state to have to rebuild them and put judges back in their seats. We basically have to create a system all over again. So I can definitely agree with that. Someone earlier had mentioned something about a bill, too, that went to the age of 21. And I'd have to say I think I would have never gotten a day in court, as let's say here in our house, with something of that drastic measure. That one, when I heard that, I was actually kind of shocked to hear it to 21. Especially seeing how most of the United States is set up system-wise, 18, banks, systems, everything, even the tax system. So that one was odd to me. I don't think we'll see anything like that in the state of Missouri, but I want to thank everyone for some of the information and ideas that I got out of this today. This has been my first time that I sat in on one of these. I was actually supposed to be in another meeting. I was only supposed to be on the line for a short period of time, and I decided I'm going to forego that meeting because this is definitely more important. So I appreciate it on this time.
Yeah, thank you, and we definitely appreciate you giving us the time. That was Connecticut is the state where, and it looks like we've had some other information come in that they are planning on introducing a bill this year that would raise the upper age to 20, so 21 and over would be an adult. But
I'd be really curious to see how that comes out. I'm going to keep an eye on those states. Thanks for that information as well, because I just like to kind of see what's going on when it comes to the juvenile side across the state, and that's ones I'm going to watch just to see the reaction they get on that.
Yeah, definitely, and we'll have after this is over, when we have the archived version of the webinar on our website, we'll also post all the resources that were mentioned on that web page as well, so you'll be able to access anything that was talked about during this conversation. So just thank you, Representative Hicks, and we're going to move on now to the question and answer.
I am going to have to step out, everybody, but I do want to thank you for your time and everything today. If anyone has any questions, they can email them to me, or if you have a quick moment for me to answer any, I would gladly do so, but I am going to have to get to my next affair here.
That's okay. I'll pass them along when I get them.
All right, appreciate it. Thank you.
Thank you so much. Have a good one.
You too.
Okay, so just want to point out a couple of things on our final slide here. It's just some of our NCSL resources that address these and other issues related to juvenile justice. The first one, and again, on the downloadable slides, these are all live linked. So one is our Legis Brief, which covers some of the recent legislative actions on raise the age in a little more depth in the citations. The second is our juvenile justice database, so it's all pending and enacted legislation, and it goes back, I think, to 2011, if I'm not mistaken, but we have that still going on and up to date this year. And then our juvenile justice trends, which gives you a little bit of a retrospective on these issues and some of the related issues like waiver and transfer too. And so with that, I guess the first thing I would ask, and I would ask of Brandy and Stephanie and JJ, if you'd like to weigh in too, is it's come up in a couple of different places that one of the challenges with some of the legislation that's been proposed has been how do you get counties, and especially smaller counties, on board in terms of some of the fiscal concerns that they come across. Is anybody prepared to have with a remark on that?
Well, I can tell you that in Illinois there was a great deal of concern, especially for those counties that didn't have their own detention center, that they, so they were paying another county per diem to house youth. They were very concerned about the impact that this would have. And the commission actually set aside some funds to have available on an emergency basis in case there were any sort of kinks that had come up. And to date, nobody's requested those. In the end, there was, as you saw, an uptick in juvenile detention that mimics in 2015, 2014, 2009, or 10. But mostly, there has not been any reduced impact fiscally to the counties. So although it was a concern and that was sort of discussed and addressed as well as it could be, that didn't pan out. The other thing that we do have, however, is something called Redeploy Illinois that helps the state to, it's a type of reinvestment that pushes state money out to county services in order to prevent state commitments of youth. And that program has expanded, or was expanded during this time. Also, so it's sort of running on a separate track, but I think it's part of the reason that you didn't see counties sort of responding to fiscal concerns by pushing more youth into more serious charges or state incarceration.
Thank you. I think at this point we're pretty much over time, and I'd like to apologize for that and thank everybody for hanging in there with us. And so I'd like to thank you just for attending our webinar on the age of juvenile court jurisdiction. Thank you, and if you have any other questions, please feel free to use my email address, which is at the bottom of that slide, to get in contact with me. And if you have any other questions that have popped up in the box there, I'll get back to those individually. Again, thank you, and enjoy the rest of your Friday.